Hello and welcome to the last session of day one of AMP Up 2026. I am Alexia Plattenberg, Senior Product Marketing Manager here at Gather Up. I am sure you've probably seen me all day, and so you are probably most excited to see our actual speaker, Michael Atleson. And so this is the enforcement era, what the FTC's consumer review rule means for your brand. We've talked about it a lot. We've been talking about it all year. We talked about it last year, but fake reviews have always been a problem. But for a long time, those tools available to actually do something about them were limited. That's changed. The FTC's consumer rule review is now in effect, and with it comes the real possibility of civil monetary penalties, which none of us want to deal with. This isn't a theoretical shift, it's an enforcement error, and brands that aren't paying attention or taking on the risk they may not even know that they have. This session is your opportunity to get ahead of that. Michael Addison, our speaker, has spent nearly 20 years at the FTC's Bureau of Consumer Protection, and he didn't just watch this rule get made, he co-led its development. As senior staff attorney in the Division of Advertising Practices, Michael Addison managed enforcement matters related to AI and consumer reviews, authored reports to Congress, and wrote the business guidance that companies are relying on right now, to stay compliant. He's now a partner at DLA Piper, and this is a rare chance to hear directly from the person who helped write the rule on what it actually means and what it takes to stay on the right side of it. Everyone, please welcome Michael Addison. Michael, welcome.
Thank you very much, Alexia. At DLA Piper, I'm in our AI and data analytics group working with a broad range of companies on AI governance and regulatory compliance. But I also work on a broad range of advertising and other consumer protection matters. And that all draws on the experience that Alexia was talking about, which is roughly about 25 years of experience in federal and state government, with the last 19 plus at the FTC, ending in June. Like Alexia said, I was one of two lawyers who developed the consumer reviews rule, as well as the 2023 revisions to the endorsement guides. I also had a hand in a number of the enforcement actions the FTC took over the years involving reviews. So why did the FTC think it was important to issue this rule, given that it already had a long history of cases before the rule involving reviews and testimonials, based on the FTC Act's broad prohibition on deceptive or unfair business conduct? If you don't know, you could probably guess, but it's because so many people, of course, use reviews to decide what to buy and from whom, and so many companies rely on them to grow, because fake reviews are prevalent and hurt not only consumers, but also honest businesses, because the problem wasn't going away despite efforts to mitigate the problem. And because a rule, and here's the thing, Alexia mentioned this too, because a rule gives the FTC more power via civil penalties for knowing violations, and thus maybe, hopefully, a stronger disincentive, at least for bad actors within US jurisdiction. The rule was intended to reflect what the agency already believed was clearly deceptive or unfair under the FTC Act. And thus, the idea was not to burden honest businesses by giving them something else to do. If they were on the right side of the law, they already weren't doing any of the things that the rule prohibits. I don't want to give you a big rundown of every single thing in the rule. That would be boring, and we don't need that. But I will just give you a little refresher on a few of the highlights. The rule prohibits, among other things, creating, selling, or buying fake or false consumer reviews. We used creating and not simply writing to make sure that we were covering AI-generated reviews. It also prohibits providing money or other incentives contingent on writing reviews expressing a particular sentiment, whether positive or negative. Some people ask, well, why didn't you just prohibit all incentivized reviews? Platforms, third-party platforms often do that. It's because the FTC is constrained by what is made illegal in the FTC Act, deceptive or unfair conduct. And for something to be deceptive, it has to be material to consumers. Not all incentives are material to consumers, or would be. And if they're not material, there's no deception. If there's no deception, there's no law violation. So the FTC can't turn it into a law violation within a rule. Congress could do it. The FTC can't. And that's why platforms can have a stronger policy than is in the FTC rule related to incentivized reviews. Another provision in the rule is failing to make disclosures about certain insider reviews, like when officers or managers of the business write reviews. This provision used to be fairly simple and straightforward. And over time, during the rulemaking process, it got a little bit more convoluted as people both internally and externally pointed out some issues about trying to make it more fair and clear in application. And it's probably so convoluted now that if I was in charge and starting all over again, I'd say, let's just scrap it. But it's there. And, overall, the advice would be if you're having insiders or their friends and family members writing reviews, make sure they disclose it, even though there's various provisos and limitations in that provision where you might not have to. The last one I'll mention is misrepresenting that a set of reviews on a marketer's website are all the reviews received when some were in fact suppressed based on rating or negative sentiment. It's important to know that any deceptive or unfair practice involving reviews or testimonials, which the rule doesn't cover, is still subject to the FTC Act. And we'll get to an example of the FTC taking action, not under the rule, but under the Act within the last year in a reviews case. Other people often ask, why aren't you covering third-party platforms? Aren't they partly responsible for all the fake reviews? The main reason is Section 230 of the Communications Decency Act, which makes most cases the FTC could bring against a third-party platform for fake review content impossible to bring. And so the agency wasn't about to issue a rule that would be struck down before it even went into effect. The endorsement guides and its accompanying long set of FAQs don't have the force of law, but they do have many principles and illustrative examples about reviews that go beyond the rule and explain what the staff thinks about certain situations and whether it would violate the law or not. So it's a very helpful source of advice. Just to give one example, there's a section in there that says advertisers shouldn't take action that have the effect of distorting what consumers think of their products in terms of procuring, suppressing, boosting, organizing, publishing, upvoting, downvoting consumer reviews of products. So it doesn't say like you can't organize your reviews. It just says it's possible that you could organize them in a way that the agency would find to be deceptive. The last source of authority I'll mention is something even more informal, and it came out well before the rule, but there's some plain language guides for marketers and for platforms on reviews, and they are, even though they're a little bit older, they're still very good guidance. And they suggest things like, don't ask for reviews only from customers you think will leave positive ones. And we'll come back to that in a minute because it came up in a recent case. Speaking of cases, let's talk about some of the recent cases on reviews and what they mean. I'm going to start with one from 2024. The rest of them are from this administration, but I want to start with this one because the vote was 5-0 back when the commission had 5 commissioners from both parties. And the current leadership was on the commission at the time. So it was bipartisan approval. And it was against a company called SiteJabber, the only case I'm going to mention that was actually against a review platform. And I was part of the team that investigated this case. The company in the settlement here agreed to stop an alleged implied misrepresentation that reviews of a product or reviews of a company all came from individuals who had already received the rated product, as opposed to individuals who were merely asked to rate their shopping experience at the point of sale. And the FTC alleged that when you mix all those reviews together, it inflated overall star averages in a way that people would not have understood or expected. Now let's get into the cases last year in this administration. My favorite one was I wasn't involved in this one, it was after I left, is called NextMed. This is from July 25. This is the case that shows that the agency will still bring review cases under its general consumer protection authority, even if there's no rule violation. The focus of the case was deceptive weight loss claims for a supplement, but it also included a novel allegation of unfair practices involving the manipulation of the favorability of reviews on a third party platform, in this case, Trustpilot. And it leaves some open questions about some practices, like selectively soliciting reviews from satisfied customers, like offering compensation for customers to remove or change honest negative reviews, or like flagging or disputing negative reviews with a third party platform without a reasonable basis. Now, I don't think that any of those three practices are completely uncommon. The rule doesn't cover them. The FTC has in older guidance referred to them and put them on notice, put advertisers on notice that they may be illegal. But what are the limiting principles here? At what scale does selective solicitation of reviews go from being de minimis to unfair? I I have trouble getting out of my head the taco truck example. A guy who has started a taco truck and needs reviews, and he gets a regular customer in all week. And at the end of the week, the owner says, "Can you please write a review? I really need this for my business." And then the next guy comes up, orders a taco, throws it on the ground, says, "The worst taco I ever ate." I don't think we'd say that the owner of the taco truck would have violated the law by not asking that guy for a review. But at some scale, if you're doing this digitally for hundreds and hundreds of people, you wind up distorting the marketplace. But where do you draw the line? The FTC didn't say in this case. We don't know. What about offering incentives to get consumers to change negative reviews? What if the marketer has reason to believe that those negative reviews are baseless, are based on a mistaken fact or something? Is it okay then? We don't know. What about the seller disputing negative reviews with the platform? The commission said you need to have a reasonable basis. What's a reasonable basis? Just because the owner of the business can't believe that the consumer had the experience they're talking about, or do they need some sort of evidence? Also not clear. Uh, so with that uncertainty, let's move on to the next case. And actually, just this and one more case I'll mention were both announced just in the last 2 months. Last month, the agency announced a case called TrueHeight. Just like NextMed, it's a supplement company. And the agency alleged that they deceptively marketed its vitamins as clinically proven to make kids grow tall. Sure, they do. The case included claims that it used fake reviews and posted AI generated comments from fake followers on its social media accounts. The company settled and agreed to pay $750,000. The actual judgment was $4 million, suspended because of ability to pay. The only hook the FTC had for money in that case was the consumer reviews rule. That was the value of that rule to the commission there. If it had just been about the health claims, no money. Last case, which was just announced on Monday, was against a company called Premium Home Service and its owner. With the Illinois Attorney General, the FTC sued this company for creating thousands of fake online business listings for home repair companies, allegedly to deceive consumers into thinking they were choosing reputable local companies for that work. The complaint also alleges that they posted or had employees or relatives post or had SEO companies post on Google fake 5-star reviews from fake customers of the fake companies in order to dilute the impact of legitimate 1-star reviews from real customers. They also allegedly posted fake reviews on the App Store because the company had its own app. So the FTC said this conduct violated the rules, prohibitions on creating fake reviews, buying fake reviews, and procuring fake reviews from company insiders. So this is an application of that convoluted provision I was talking about. All these cases show that the FTC is clearly willing in this administration to enforce the rule and to bring review cases under its general consumer protection authority. Those cases might also suggest that maybe allegations relating to reviews will mostly just be adjuncts to cases that they're already bringing about something else, like a health product or business opportunity scam or the last case about fake business listings, except for one thing. To go a little bit further back, in December 2025, the agency issued 10 warning letters specifically for purported violations or possible violations of the consumer reviews rule. The FTC released a template letter, but didn't identify the recipients of the violations or the actual letter. So we don't know who got them, what kind of companies they were, or what parts of the rule the agency was focusing on. We didn't know it then. Hat tip to Mike Blumenthal, who sent the agency a FOIA request, resulting, as it often does with warning letters, in the agency releasing the actual letters and eventually posting them on their website. But they didn't make a big deal of it. In fact, it's almost impossible to find unless you have the URL. So now we know about these letters. 6 of the 10 went to property management companies. 3 went to personal injury law firms, and the other one went to a CPA firm. The purported misconduct for all 10 of them was effectively the same with some factual variations, providing money or other incentives like lease discounts, gift cards, raffle entries to tenants or customers or employees in exchange for them posting or getting family or friends to post positive reviews, often specified as being Google reviews. Why property management companies, law firms, and a CPA? It's just speculation, but I think it's because they deal with things that are very important to people, where they live, how their legal rights are defended, how their finances are handled, consequential things, as distinct from, say, a review of a restaurant. I am a little surprised by the lopsided representation of real estate related companies and the relatively narrow focus on paid reviews, and maybe the absence of other consequential businesses like, let's say, medical offices or auto dealers. But I imagine that the agency had its reasons. I have some theories. One is that this is just the first tranche of warning letters. That is, it's what the agency decided to focus on first based on what they had, and it's not the last word. And it's also likely that the FTC found these companies via their very, very large complaint database. But just because it's large doesn't mean it's a representative sample of all suspected fake review campaigns. So it might just be what they came up with, and they might have been looking for particular themes. In any event, despite the agency's very limited resources, it does continue to look like it is very happy to bring cases involving deceptive or unfair reviews. It may still be more likely that it's going to only do so in cases that are principally about something else, like cases I mentioned, but the warning letters are a signal that it is willing to do review focused cases, especially given the prospect of otherwise unavailable civil penalties. So, advertisers and sellers, since they're the main actors on which the rule focuses, need to be mindful of this really active regulatory background when they're designing and implementing and monitoring the review portions of their sites and any review campaigns. Last thing is, I mentioned the Illinois AG before. State AGs are another source of potential enforcement here. They have basically the same consumer protection prohibitions on deceptive and unfair conduct as the FTC operates with. And so are international regulators, including the Competition and Markets Authority in the UK, which has started to become very active in the review space as well. So this is no time to be complacent about compliance. And I will let Alexia come back in with any question that there might be.
Thank you so much, Michael. I really appreciate that. And it was very eye-opening because I think that a lot of the times people are hearing about this enforcement era and these enforcement rules, but they're not really sure the size of the impact or the problem that even caused people. caused your organization to even have to put these protections and guardrails in place for consumers. And so I really appreciate that background and history. We had some questions come in prior to the session, and so I just want to take the opportunity to go through those. And the rule didn't create new prohibitions. Fake reviews were already illegal. So for brands doing the right thing, what actually changed on a practical level when this rule went into effect? Why should they care?
One reason they should care is it means that the agency is taking these issues very seriously, and it was considering what problems in the review space are the most prevalent. What things did the agency have the most evidence about, either from prior cases and investigations or other types of research out there, and what it thought were the biggest marketplace problems. So even though the FTC, even without this rule, could bring cases involving deceptive or unfair reviews, the things that are in the rule are the things that the agency is going to focus on first, not only because they think they're most important, but because they have the biggest hook, and like I was talking about in terms of money. It's true that everything in the rule reflects things that the FTC already thought were illegal, but it's possible that some brands and folks in the industry um, didn't understand that the FTC thought so, including issues involving, you know, campaigns to get your family and friends and employees to write reviews, and the importance of trying to get them to disclose their relationship. And there's also um, some interesting aspects of the rule that don't relate specifically to reviews. Like the last section has to do with um, social media influence and the buying and selling of followers and likes to try and boost up a brand for some commercial purpose, which is mostly based on outside evidence and one case the FTC brought several years ago. So there are a number of things that you wouldn't necessarily think would be in the rule, or that were necessarily considered illegal before, that's important to take a look and make sure that you're not doing any of those things.
Absolutely. And I think that, like you said, it became prevalent, but I didn't realize that it was something that federal regulation was being mapped around people or brands or influencers buying profiles or followers or likes, and how damaging that could be and how inauthentic it is um, to the visual space. I do think there is a gray area though, and someone had this question: where do you see the most unintentional non-compliance? What are some things brands are doing that they don't realize actually put them at risk?
One thing that comes to mind, because I think it happens often, is when a brand enters into an arrangement with some third party, whether it's an SEO company or advertising agency, or some other company that is going to try and boost its reputation, boost engagement, boost the number of reviews, and it might tell the brand, "Don't worry, we comply with all rules, FTC, blah blah blah." Um, but in fact, the way that they're able to get results is via some kind of fakery, whether it's fake reviews or fake likes on social media or fake posts from people or paid posts. Um, and the brand doesn't even necessarily know that, but they're still on the hook. They can't point just in consumer protection law generally. Just because it's a vendor or an agent or some other company working for you that has done the bad thing, you can't avoid liability by simply pointing at them. So you need to be monitoring what those companies are doing in your name.
Absolutely. No, that makes sense. But I do think it brings up a good follow-up question when we were talking about the gray area. Taryn says she feels like she may have missed it, but she's not sure what the actual rule is. She just knows some examples of how you may violate it. Is the rule the point of being a gray area, or do we need to know how, or we don't know how each situation will be impacted? So I can send a link to the press release that the FTC released, but would love to hear from you what the rule is exactly, and why brands should know that structural foundation.
Rule is not hidden. It's on the FTC website and elsewhere, and there is guidance in the form of a blog post that kind of lays it out a little bit more specifically, and plenty of other articles there about it. But no one's trying to hide what the actual provisions are. And it's very specific with a lot of definitions about sort of what counts as a review and what doesn't. But there are a number of provisions. Probably the most important one is one that explains that you cannot, create or write or buy a fake or false review, and that those terms are defined as well to mean, review that, for example, does not reflect the experience of the reviewer. So it's if you want, more specifics about any of the provisions, please feel free, anyone, to contact me at the firm and can point you in the right direction or give you the language.
Absolutely. And I would say, like high level, Taryn, what I gathered and how I anticipated it is fake reviews have been in fact impacting consumers. It's a $152 billion problem in 2024. I'm sure there is more money that consumers have lost by interacting with brands who do leverage fake reviews or manipulated reviews to misrepresent their business. What this new rule puts in place is an enforcement structure that penalizes and holds those businesses accountable for doing that, whether they're aware that they're doing that or not. And so there are going to be several cases or several ways that that rule can be violated. The rule just actually provided the framework to enforce and punish, or I won't say punish, that sounds like toddler, to enforce and hold accountable any brands who may be violating that, which we've seen from Google's removal of reviews. It's up 25% year over year, almost 70% from 2024 to 2025. And so people are actively leveraging inauthentic customer experiences, whether that's your competitor, kind of having sending people to spam your profile and say bad things about you, whether you're buying fake reviews, so you can get a ton of five-star reviews, whatever that looks like. There's a lot of manipulation going around, and so this just created the framework to protect consumers best. Jan Wenzel had a question. She said, "What do you make of the latest policy around employee names being mentioned? Google's latest policy says businesses should not ask customers to include specific content in a review, including content that identifies a staff member by name. And Google also says merchants should not ask staff to solicit a specific number of reviews."
Um, those are those are really policy questions. So the last one, I do this is just my personal opinion, but I do think it can be um, problematic when employees are, sort of directed to try and are incentivized or directed to, even if it's not, write the review yourself, and then get your customers to write reviews. And if they mention you, you get some sort of bonus or award of some kind, um, because that, may give the wrong incentive to those employees to write fake reviews themselves, pretending to be somebody else, or getting their friends and family to do it when they really haven't had that experience. And I assume that is what Google is up to there. So I do recognize it's a concern. I'd be interested in knowing if people think that goes too far. It's not something I've thought of too much, but it's certainly something as a consumer that I've seen and thought, you know,
Yeah.
that might be giving employees the bad incentives here.
Yeah, I would say I was being in the reputation space. I'm always aware when I'm patroning a business and an employee asks me for a review. I'll never forget. I was at a restaurant and one of the employees came and brought their QR code and they said, if you enjoyed your experience, it'd be great if you could leave a review with my name. That's how they're deciding to put people on the schedule. And so now I felt really compelled. I was like, this is this person's livelihood. I don't want to not, I want to help this person. And so while I did have a good experience, I do feel as though, I would say I felt pressured as a consumer, and like this person's ability to keep shifts or get more shifts is impacted by that request and the way it was framed. But I also understand what Jan's mentioning. It feels as though Google is trying to solve a fake review problem, and this is my opinion, this is not the opinion gather up. It feels like they're trying to solve the fake review problem by also penalizing quality reviews, reviews that were also telling people help them get found in AI search. And so they're
Yeah.
trying to limit the problem, but it's also with any new policies, there's going to be unintended consequences. And so navigating that, the good news is nothing is permanent. And I know Google is adapting and evolving. But it's something that, we're all trying to figure out. But I absolutely loved your feedback that it's more policy and it's not really something we can definitively say where Google's mindset is and why they've made that decision. We do have another question here. I know we're at time, but I do want to get this one asked. Dale says, what official procedures should be followed if a business is suspected of utilizing fraudulent reviews?
So, so whose procedures? Like if
Brand
the business is
or
being accused itself, what do you do then?
I would say
Or
yeah, Dale, from your perspective, are you asking, what should, if you're the brand and you're suspected, or are you asking if your competitors are suspected of utilizing fraudulent reviews? That does vary based on the answer. And so if you can offer a little bit of context there, that might competitors. If competitors are utilizing fraudulent reviews, what procedures could a competitor in this, like if I recognize as a competitor, what could I do to hold them accountable or make the FTC
yeah,
aware?
I'm afraid I do not have the best answer here. When I was at the FTC, we often had competitors come to us with very compelling um, accounts of competitors doing this kind of thing on Amazon and plenty at Google and plenty of other places. And they were lucky if they managed to reach someone at the agency because we could then pass their information on to people that we knew at one platform or another to tell them, can you please take a look at this? My understanding is the reporting mechanisms at some of these big platforms are not so great, especially if you don't have a lot of just to get noticed. First of all, is hard, but especially if you don't have a lot of evidence to back it up. Like if it looks to them like a he said she said thing, they might just not pay attention to it. And that's in part because sometimes these platforms um, have concerns that the person complaining about a competitor's reviews or fake negative reviews that a competitor has put on there that like are just trying to get one over on them.
Yeah.
Um, so the best procedures are simply to and it takes resources, but to document everything as much as you can. Try complaining to not just the FTC, but also the Better Business Bureau if they have Better Business if they have BBB reviews, to state AGs, whatever state AG is responsible, both like where you are and where the competitor is, and and keep pestering the platform until you can figure out a way to get someone to pay attention to you. Sometimes, if you go to the BBB or to you can find an attorney at the FTC who will listen to you or an investigator or one of the consumer resources people there. You can get them to help on your behalf.
I love that. And that's a really great answer. And I want to point out to attendees, Michael had a really great response for people who don't have a resource or a tool in place. But I would be remiss as a PMM to not mention that GatherUp has actually developed a tool that has a third-party watchdog where we verify and validate the validity of reviews on Google profiles based on Google's own algorithm. And so what we do is we monitor both your profile and your competitors to validate the quality and authenticity of those reviews, and then they're subscribed to suspicion score. And the reason I bring this up is because a lot of the times brands think, oh, there's no way this competitor is getting this many five-star reviews. We're in the same market. There's no way they have to be buying them. And a lot of the times, that it's the case, but also a lot of the times that's not the case, and those do turn out to be authentic reviews. And so the best thing you can do is gather the evidence through a verifiable tool that can help you. And one of the things we do is we automate the process. We scan review profiles every day, daily. So any new reviews coming in, we authenticate to make sure that they are accurate, not only protecting you and your brand, but also to make sure that as an honest brand, you have a way to level the playing field against any competitors who may be acting maliciously. And then you have the documentation to prove that. And then we help automate the dispute process for you. And so if you want to learn more about that, Jason Wortham, our VP of Customer Success, loves talking about it. he has a session tomorrow when reviews go wrong. I highly encourage you to attend that session because he'll go into detail about how we go about validating that information for you and making sure that you actually have the opportunity to protect yourself and level the playing field against competitors. And so, Michael, this was the perfect session to close on. Thank you so much. I really appreciate you being here. Your insight is paramount because it's really shaping a lot of the conversations we're having. And I have the thought leader and the person who co-led the development of the rule is really helpful. And so thank you so much for your time. Thank you for everyone who attended day one of AMP Up. Again, we do have day two tomorrow. We start bright and early, 10 a.m. my time, 11 a.m. I just want to be I want to let me double check because I think I've been getting my time zones wrong. Nope, that's right. 10 a.m. my time, 11 a.m. Eastern. We'll start with AI as your co-pilot. And like I mentioned, if you enjoyed the conversation today, if you found what Michael said to be insightful and you want to learn maybe what some tactical things you can do next, two sessions I recommend for you tomorrow. When reviews go wrong, spotting fraud and defending your reputation with Jason Wortham. That's at 1:40 Eastern tomorrow. And then our closing session where Michael will talk a lot more about our True Review certification and how brands can show up honest and authentic, especially in the era of AI, where AI is rewarding authentic businesses with local visibility. Thank you so much. I hope everyone has a great evening, and I will see you tomorrow.